We are getting close to the end of the semester, so let's step back and see where we've been. You'll remember that on the very first day, I showed this picture or map of the world of tort law, and I said that it's organized around the concept of fault. And we saw that there are two basic types of fault. One is when you intentionally do something that's harmful, and we learned all about intentional torts like battery and so on, and the defenses to those claims. And the other type of fault is when you negligently do something that's harmful. You didn't do it intentionally, but you failed to exercise reasonable care. And we learned all about negligence claims and the elements of them and the defenses to them. That leaves one layer of torts here that we haven't said much about. It's the box for situations in which someone is liable for causing harm even though it wasn't intentional or negligent. We call this strict liability or liability without fault. And it is rare. There are only a few unique situations in which we impose liability without fault. We only really talked about one sort of possible strict liability in here. We covered respondeat superior, where an employer would be liable for the tort of an employee. And you might think of that as a type of strict liability, but people tend to think of it more as a type of vicarious or derivative liability, with the master being vicariously liable for what the servant or employee does, even though the master doesn't actually do anything intentionally or negligent. There are other types of strict liability, but we're not going to focus on them in here. But I want to mention them just as a reminder that they're out there. Some of them are somewhat weird old rules. For example, there is a rule that you are strictly liable if you decide to keep wild animals, like lions and tigers and bears, on your property. So if you have a leopard and it gets loose and kills somebody, you would be liable even if you weren't negligent and didn't act intentionally. That one doesn't come up very often, but occasionally there will be a situation where it does.
It's a scene out of a far-fetched horror film. 48 exotic animals, many of them man-eaters, are roaming the countryside of rural Ohio.
There were grizzly bears and black bears there. There were cheetahs, there were lions, and there were tigers.
Animal farm owner Terry Thompson was found dead, his fences open.
There are limits to this. It covers situations where the wild animal gets loose, where it's not supposed to be, or where you let somebody come onto your property and encounter the animal. So if you break into somebody's house and try to steal their tiger and you get bit by it, I don't think you'd have a claim. It's limited to situations where the harm that occurs is something connected to the wild or dangerous character of the animal. So like if a lion bites you, there's liability, but maybe not if it was just sleeping on the ground and you tripped over it. Some courts also reject this strict liability doctrine when it comes to public entity defendants, such as public zoos. It can also be difficult to define what animals are considered wild. For example, there are some places in the world where elephants might be regarded as domestic animals, because they are kept and do work like horses would. But in other places, elephants would definitely be considered wild animals. In some places, there are statutes that impose strict liability from injuries even from non-wild animals, particularly for dog bites. Another sort of strict liability is for ultra-hazardous or abnormally dangerous activities. These are things that are really dangerous no matter how safely you do them. The classic example is blasting things with explosives. For example, if you're a construction company and you use dynamite to blast a foundation for a building or a tunnel, the traditional rule was that you'd be held strictly liable for any harm that you cause. So even if you're the most super careful and reasonable dynamite blaster in the world, you'll have to pay if your blasting causes some harm to someone, such as if it were to break the windows of a nearby building. Again, there may be limits to this. For example, there was a case where blasting was being done and it disturbed the mating of minks who were being raised by someone for their fur. And the court said that's not the kind of harm that we have in mind that we expect to occur as a result of blasting things with explosives. So there was not strict liability for that. Finally, the most important and most recently invented form of strict liability is for defective products. Starting in the 1960s, courts made up a new rule that you can be held strictly liable if you sell a defective product. You can learn more about that if you take a course on products liability. So we've learned about all these different types of tort claims, and we looked at how to allocate the damages among the defendants when you've got multiple defendants that are liable. But one thing we haven't specifically studied for any of these torts is what you get if you do prevail on one of these claims. What are you entitled to as a remedy? What determines the amount of damages that you are awarded? Plaintiffs in torts cases occasionally seek other remedies, such as injunctions, but that is rare. Someone, for example, might seek an injunction out of a concern for other people's safety, like getting the design of a product changed to make it safer for everyone in the future. Or you might want injunctive relief that is more specific to you, like an order to force a neighbor to stop doing something that was harming you, like to enjoin a nuisance. But for the most part, the remedy for torts is damages, money damages. There are two types of damages, compensatory damages and punitive damages. We'll start with compensatory damages today. If you think back to the very start of the semester, we looked at several possible purposes of tort law, and compensatory damages certainly serve at least two of these purposes. One is compensation. The damages are supposed to compensate the plaintiff for the loss that the plaintiff suffered. And the second purpose that damages serve is deterrence. The possibility of having to pay these damages gives people an incentive not to commit intentional torts or not to be negligent. So what exactly can you get compensatory damages for? The simplest situation is where you just have harm to property. And that is the simplest because it's usually easy to put a price on property. It's easy to assign dollar values to property because people buy and sell property all the time. So in general, if your property is destroyed or permanently taken from you, you would recover the full market value of the property. If the property is damaged, you might recover either the reduction in the property's market value or the cost of repair. As to which of those measures would be better to use, there's no particular rule. It's just whichever seems more fair to the decision maker, the judge, or the jury in a particular case. And if you temporarily lost possession of property but eventually recover the property, you might recover the rental value of the property. So, for example, if someone totally destroyed your car, you'd get the full value of it. If somebody dented it, you'd get the cost of repairing the dent or perhaps the amount that the car's value was reduced. And if you were prevented from using your car for a week, you might recover the cost of renting a car for a week. For a personal injury, meaning a physical or bodily injury to a person, it's a little harder to say what the plaintiff should get. It's a little harder to agree on what a person's life, or their eyesight, or their ability to move their hand is worth. But the damages fall into two basic categories, economic damages and non-economic damages. Today we'll focus on what you get if you live, if you survive the tort. And next time we'll talk about what recovery is possible if, unfortunately, you die. Your economic losses, which are sometimes also called pecuniary damages, would include money that you had to pay, so money that comes out of your pocket, like if you have to pay a medical bill as a result of the injury. It would also include money that you missed out on receiving, so money that you otherwise would have received. So, for example, if you were injured and you couldn't go to work, you might lose the opportunity to receive your wages or salary. On the other hand, non-economic losses or non-pecuniary losses are money that is supposed to represent the somewhat more intangible things like your pain and suffering, your loss of enjoyment of life, or the physical impairment or disfigurement that you might have suffered. One thing that can really complicate this is timing. Sometimes people suffer an injury that is just complete and done. Whatever harm you suffered is over and done, and it's entirely a past thing. And so by the time the jury is deciding the amount of damages to award to you, they're just looking backwards at the past to decide how much harm you suffered. But some types of injuries have a continuing effect. Some injuries might affect you for the rest of your life. And so at the time of the trial, there may be forms of harm that you'll be suffering in the future. You might have future medical expenses, or future lost income, or future pain and suffering. So what do we do about that? One possibility, I suppose, would be to say that you can only recover for past injuries and not future ones. We could say that we're not going to guess about the future, and perhaps we could have rules that permit you to come back later repeatedly as the harm plays out over time. That would be possible, but that is not what courts do. Instead, the law requires the jury to decide everything all at once, and then all of the money for past and future injuries is paid out to you in one lump sum up front. That means the jury has to estimate what the future part of your damages will be. They have to make the most reasonable prediction they can about what will happen in the future. And that leads us to our first case, Martin versus United States. You may have noticed that there was no jury here, and the note after the case explains why. There's no jury because this was a claim against the United States government, and so it was brought under a special statute called the Federal Tort Claims Act, and claims under that statute don't go to a jury. But don't be misled by that to think that judges usually decide the amount of damages, as this judge does here. It is usually the jury who deliberates and decides all the dollar figures for the damages. But here it's a judge, which is actually nice for our purposes because it means there is an opinion that explains the reasoning behind each item of the damages. That's not something we'd get from a jury. The opinion goes through the damages analysis for each of the boys, and at the end it lists the total damages for each of them and each part of the total. The first item listed is past medical expenses. I think that one's pretty straightforward to understand what that is. That's medical expenses that have already been incurred. And it's pretty easy to determine what the amount of that should be because you can simply look at the medical bills. The next item is future medical expenses. So what is that? It's an estimate of future medical costs. Basically, doctors would testify about what they think the expenses are likely to be for the person's medical care for the injury in the future. Notice that the damages for this included $5,000 for psychological treatments for Melvin, so it could include mental health as well as physical. How would the judge, or usually the jury, come up with an estimate of future medical costs? The opinion doesn't really explain how it was calculated here, but generally you would have doctors who testify about what they expect the future costs to be. The next item is loss of earning capacity. This is an estimate of future lost income. A working adult who was injured would probably have lost income for the past as well. In other words, between the time of the injury and the trial, there would be some lost income. But these plaintiffs here are children, so they don't have lost income from the past, only lost income from the future. The court predicts that these boys, if they had not been injured, would have become skilled workers, like a carpenter, for example. How does the court know that? I mean, these kids were like 12 years old, so what sort of evidence is presented to show what their job or future earnings would be? As you saw, the opinion talks about several witnesses. One was the school principal, one was an economic or financial expert who was brought in from a local university by the plaintiffs. On the other hand, there were expert witnesses for the defendant's side as well, a psychologist and an economics professor, and they predicted that these boys would not have been skilled workers and instead would have received just average wages working as laborers. Do you think this is reasonable decision-making based on the evidence that's available, or does it seem like pretty wild speculation? The court says that they're making reasonable approximations as best they can, but it is all very speculative. Notice that the court also talks about whether Melvin would be able to do some sort of job despite the burns he suffered. The court decides that he could work at an entry-level position for at least half of his life. The plaintiff's expert doctors said he wouldn't be able to work because of his injuries, and on the other hand, the defendant's expert doctors said he could work a nighttime job. So the court seems to split it in half and say he could work part-time. Now here's something that gets a little complicated. Notice that in the opinion, the court says it thinks that 5.5% is a reasonable annual rate of wage inflation to be expected during Melvin's working lifetime. The court also says that he finds the award can be invested at very little risk and return 7.5% compounded annually. So what is the significance of all that? These are all complications that result from the timing issue. The fact that we're going to compensate someone for a lost stream of future income, but we're going to do it by giving them a single lump sum payment right now. And as a result of doing that, we have to make certain adjustments, both upward and downward. We have to adjust the amount they are awarded upward to account for future inflation. In other words, if we just give them damages based on the current wage levels, well, we assume that in the future the wages are going to go up, and so we'll be undercompensating them unless we adjust it upward for inflation. But we also have to adjust it downward to account for the fact that they'll be getting all the money right now, and presumably they could invest it and it would grow. It would be just like if you win $1 million in the lottery. They give you an option. You can take $1 million, but it'll be paid out over 20 years. You'll get $50,000 a year for 20 years, and it will add up to $1 million. But they'll also give you the option of taking a lump sum right now up front. If you do that, the lump sum payment will be less than $1 million. And it reflects the time value of money in economic terms. It means you could get the money now and invest it and wind up with a higher amount later. So what this means is that you have to make guesses about what inflation rates are likely to be in the future and what investment returns are likely to be in the future, such as interest rates. Now, this decision was made in 1979. At that time, the American economy was not doing well. The inflation rate at that time was about 13%. And this judge apparently realized correctly that that was abnormal. He predicted that future inflation would average 5.5% per year. And, in fact, the inflation rate since 1979 has averaged about 4%, so he wasn't too far off. In 1979, interest rates were also relatively high. For example, what they call the 10-year Treasury rate was over 9% at that time. It actually went up even higher for a few years in the 1980s, but for a long time now it's been quite low. So again, you've got to do two economic adjustments to the damages. You have to adjust the award upward to account for inflation, and you've got to adjust it downward to account for the fact that it's being paid all up front in a lump sum. Now, for this class, you don't need to know anything about actually calculating these adjustments. But I mention them just so that you can be aware that they exist, and if you're ever going to handle personal injury cases of any kind for plaintiffs or defendants, then you will someday need to be familiar with how these adjustments work. And they are complicated, which means they'll often need to hire a damages expert, an economist or an accountant, who can do the calculations and testify about them. The last item of damages here is pain and suffering. How does the court determine that figure? As you saw, the judge talks about the effect that this accident had on these boys, the pain, the operations they have to endure, the disfigurement that they'll be left with, the reactions of other people. And the judge just comes up with an amount for all of the non-economic damages together. He calls it pain and suffering, and he does his best to determine what he thinks the proper amount would be. I thought the footnote at the beginning of the case was interesting, where the judge talks about the difficulty of trying to be dispassionate and objective, but at the same time not being insensitive to the tragic consequences. It's a delicate balance, because you shouldn't be too cold and desensitized to the impact of this. But you also can't get carried away with emotion either. And I thought the judge was very candid about that, giving insight into the difficulty of the judge's task here. As I've said, the customary approach of awarding all the damages right now in a lump sum means we have to do a lot of guessing. In this case, they had to guess about what jobs the boys would have in the future, what jobs they would have had if they hadn't been injured, the future inflation rates, the future interest rates, the future medical expenses. It's a lot of guesswork. One possible alternative would be to set up some kind of a system of future payouts, and then we could wait and find out what the actual amounts of the harm turned out to be. Some states have now passed statutes allowing for periodic future payments in certain kinds of cases. Missouri has a statute like this, for example, for medical malpractice claims. We could expand this sort of thing beyond just medical malpractice, and it's an interesting idea because it does have some potential advantages for both plaintiffs and defendants, compared to just the traditional approach of giving people a big lump sum of damages up front. One thing that suggests paying damages over time might be a good idea is that parties often voluntarily agree between themselves to do this when lawsuits are settled. They will enter into structured settlements with payments made over time rather than in one big lump sum payment up front. For example, the settlement may say that the defendant will buy an annuity that pays the plaintiff a certain amount of money every year for the rest of his life. We could extend this approach so that it's used for jury verdicts rather than just settlements. Doing this may be safer for plaintiffs. We've all heard about people who win lotteries and then mismanage the money and it's gone in a few years, or athletes who make a ton of money and then go broke. A lump sum payment similarly forces the tort victim to manage the award, making complex budgetary and investment choices, and some plaintiffs may not handle their damages awards wisely. But they may be less likely to mismanage a stream of payments over time. Of course, if the plaintiff is able to sell the structured settlement for cash up front, then that does sort of defeat this benefit. And everyone's probably seen ads from companies that will purchase structured settlements or annuities.
I have a structured settlement and I need cash now. Call J.G. Wentworth, I have an annuity, but I need cash now.
Awarding the money in a stream of payments over time rather than a lump sum would also simplify things for juries. They wouldn't have to make as many difficult predictions, and they wouldn't have to hear as much expert testimony about inflation rates and present discounted values and so on. And in some situations, you'd probably get more accurate amounts of damages being awarded. You could design the award so that the payments match the actual costs that wind up being incurred, rather than just being based on estimates made up front. For example, the defendant could be ordered to pay all the medical costs that are actually incurred, rather than trying to guess what the costs will be for the future. Or we could wait and see what sort of work these boys are able to do, rather than guessing about that ahead of time. And you can wait and see how long the plaintiff lives, instead of guessing about life expectancy. Awards that are paid in installments could be more manageable for defendants in some instances as well. It would be easier for big entities to self-insure themselves rather than actually purchasing insurance. For example, in New York City, it's a big place, they have a lot of tort claims against them, so they don't actually buy liability insurance. They just pay out the damages. And they're big enough that there's not too much risk in that. They can sort of estimate accurately how much damages they'll owe for a certain period of time. And if they could pay out the damages in installments, it would be even easier to do that, because a city wouldn't have as much risk of being hit with a big damages payment in any given year. It would just be a chance of getting hit with an obligation to pay a future stream of payments. Plaintiffs also might benefit from this approach by getting higher awards. Some people think juries may give lower amounts of damages when awarding them as a lump sum, because psychologically it seems much greater, even if economically it is equivalent. For example, you could have a situation where it's economically the same thing to give a plaintiff $10 million in a lump sum up front, or to give $50,000 a year for the rest of her life. But the $10 million may just seem like a lot more from a psychological standpoint. And if that's true, then juries probably undercompensate plaintiffs compared to what they do if they were awarding a future stream of payments rather than a lump sum. The other case you read was McDougald versus Garber. This was a case about medical negligence. The opinion of the lower court said the negligence here was tragically shocking, but it didn't really explain what happened, so we can't determine exactly what the negligence was. The judge here is Wachtler. This is Saul Wachtler. He's sort of a famous judge, but unlike Learned Hand or Benjamin Cardozo, it's not necessarily for good reasons. He was the Chief Justice of New York's highest court and was probably going to become the governor of New York at some point. But Judge Wachtler was arrested. He'd been having an extramarital affair with a woman, and she ended it, and he was not happy about that, so he started writing her some very bizarre, obscene, threatening letters. And in the letters, he pretended that he was all different characters. For example, he pretended he was a private eye, a detective from Texas, and he threatened to kidnap this woman's daughter.
Trace, track, tease, torment. That's stalking.
Joy began to get hang-up calls. Lots of them.
The stalker was sending cards telling her about things that he would do to her.
An innocent woman is terrorized by a sadistic stranger. Who could it be? And how far will he go?
He makes illusions. You won't see your daughter again.
It paralyzed her. It paralyzed her daughter with fear.
As the vicious threats continue, the FBI works to track down the stalker.
You have to find someone who has a motive, who doesn't like you, who is jealous of you. He had engaged in a crime that was heinous, salacious, and dangerous.
What would make a man do that?
It turned out that Judge Wachtler had a mental illness. He was bipolar, and he had been abusing painkiller and antidepressant drugs for many years. So he was sent to prison as a result of this, and it was a big scandal. In prison, he got stabbed by another inmate, and he wound up writing a book about what it was like to be a judge who sends a lot of people to prison and then has to go there himself.
One part of the book deals with, and this is just the introduction, deals with what happened to me and the mental aberration that I suffered. I am bipolar. I'm on medication now. Unfortunately, I was not on medication then. That is called a manic depressive illness. I don't say that as an excuse for my criminal conduct. It's an explanation for the manic episodes which had me writing these bizarre letters. I wish I had been arrested sooner than I was. It would have spared a lot of people a lot of grief. Instead, I was allowed to go on, and because of my own narcissism and my own ambition, I did not see a psychiatrist. I tried to treat myself with medication, which I obtained from 3 different doctors, and as a result of that illicit drug use and that mental problem, I lost all good judgment and went about doing things which I'm terribly ashamed of and which I have apologized for innumerable times. I've made restitution for it as best I can, and now I'm trying to achieve some degree of redemption.
He served about 13 months in prison, and then he got out, and he's become an advocate for people with mental illness. He is also a law professor, an adjunct law professor in New York, and he got his license to practice law reinstated at some point. This opinion was written while he was having the problems with mental illness and with drugs, but before he was arrested. So let's spell out exactly what the plaintiff's damages are here. The jury awarded $5.15 million for economic damages, $1 million for pain and suffering, and $3.5 million for lost enjoyment of life, for a total of $9.65 million. After the jury issued its verdict, the trial judge granted some motions and cut the award of damages. The judge cut the economic damages to $2.8 million. He denied the award for future nursing care, saying there was no evidence that she would need round-the-clock nursing care. And he cut the non-economic damages award to $2 million. He simply said that the jury's award was excessive. So the judge awarded a total of $4.8 million. Judges have a lot of discretion to cut excessive damages. This is something that's called remittitor, and we'll see a bit more about it in a future assignment very soon. Notice that her husband also receives a separate award of $1.5 million. The opinion describes this as a derivative claim for the loss of his wife's services. In other words, it's derivative in the sense that his injury derives from hers. She is hurt, and that in turn causes some harm to him. The note explains that this is typically called a loss of consortium claim. Suppose you suffer an injury. You're still alive, but you're physically injured and impaired. You can recover damages for that, of course. But in addition, your spouse, if you have one, will have his or her own claim for loss of consortium. And the idea is that when you are injured, your spouse also suffers some harm. Your spouse also suffers some loss. Now, it may sound crude or strange, but this concept is largely about the sexual relationship between the spouses. The idea is that if your spouse gets hurt very badly, you might lose the sexual relationship that you previously had. The concept is not entirely limited to just that. An injury to your spouse certainly may deprive you in other ways, like your spouse may no longer be working, so the family loses income, or is no longer able to help with basic household things, like cooking and cleaning or taking care of children or whatever. But the sexual relationship aspect of it really is at the core of this concept. Now again, the loss of consortium claim doesn't require that anybody has died. Your spouse is still alive but has been injured. The injured person has his or her own claim, and then the spouse has a separate and distinct claim of his or her own for loss of consortium. It's an independent, separate claim, although it's a derivative claim derived from the other person's injury. And at least in Missouri, this is only for non-fatal injuries. If your spouse dies, your consortium claim, it doesn't really go away, but it merges into the wrongful death claim. So simply, you'll recover everything under wrongful death and won't need a separate loss of consortium claim. But for non-fatal injuries, Missouri does allow spouses to bring loss of consortium claims, and this is just a common law thing that has been around for a long time. Some people have tried to argue that this concept should extend beyond just spouses. For example, suppose that you're injured very seriously in an accident, but you weren't married. Should your parents be able to bring a loss of consortium claim? Or what if you have children? Should your kids be able to bring a loss of consortium claim? Or your girlfriend or boyfriend? In most states, those arguments have been rejected, and loss of consortium claims continue to be limited to spouses only. That's true for Missouri, and in Kansas too, where this is covered by a statute that's mentioned in the note in the reading assignment. In fact, there have been cases in Missouri where plaintiffs have argued for allowing parents or children to bring loss of consortium claims, and they've argued that it's unfair and arbitrary and perhaps even unconstitutional just to limit it to spouses. But the Supreme Court of Missouri has said that it isn't going to expand this beyond spouses. If the legislature wants to do so, that's fine. But the court won't go beyond the tradition of allowing it for spouses only. And the court said, basically, look, one of the primary motivations for the existence of this whole doctrine is the sexual relationship between spouses, and that rationale obviously isn't there for claims by parents or children. The plaintiff said, well, that shouldn't be the whole focus. What about all the love and caring and the deep bond between a parent and a child? And the court said, well, we have to draw the line somewhere. We've limited this just to spouses. We could extend it to parents and kids, but we could also extend it to brothers and sisters and aunts and uncles and grandparents and somebody who is your best friend or somebody who is the most valuable employee at your business. And where would it end? So these arguments remind me of what we saw with the issue of who should be able to bring intentional infliction of emotional distress claims about outrageous treatment of another person. There, they limited it to close family members, and here for loss of consortium claims, it's even narrower, just for spouses. So in Missouri and most other states, only spouses can bring loss of consortium claims. One of the tricky things about it is making sure that the loss of consortium claim isn't allowing the plaintiffs to improperly double their recovery. For example, if you get hurt and you sue somebody and you say, I couldn't work for a long time, I lost $50,000 of income, your spouse shouldn't be able to come in and say, my spouse now doesn't make as much money as before, and be able to recover a second time for that same lost income. So the loss of consortium claim isn't supposed to allow the married couple to recover twice as much for the same injury. It's supposed to just recognize and account for the fact that the spouse may suffer some harm that is separate from and on top of the directly injured person's recovery. But it can be very tricky to make sure you're not improperly multiplying the damages, which may be another reason why the Missouri courts have been reluctant to expand this concept even further to parents and children and so on. Getting back to the McDougald case, the key issue here is that she is in a coma, and what effect should that have? You may notice that the opinion says that the jury gave her $1 million for conscious pain and suffering. And when I first read that, I wondered, how could the jury possibly give her damages for conscious pain and suffering if she's in a coma? Is that a misprint? It mentions in the case that there apparently was some evidence that she was at a level of consciousness high enough to experience pain despite being in a coma. An expert medical witness, and also a family member, testified that she was not totally unresponsive despite the coma. They said she responded to stimuli such as sight, sound, light, and touch. The defendants disputed that. They said that her brain was too severely injured for her to experience pain. The trial judge said this was a factual dispute, and it was up to the jury to decide it. And the jury apparently decided that she was conscious enough to experience pain in some way. That's why the trial judge wound up having these two things, pain and suffering and lost enjoyment of life, listed as separate items on the jury verdict form. He thought the jury should be able to give her damages for pain and suffering only if she was conscious enough to experience pain. But the jury should be able to give her damages for lost enjoyment of life even if she wasn't conscious of anything. So the main issue in this case on appeal is whether she should be entitled to recover damages for loss of enjoyment of life even though she is in a coma. Judge Wachtler and the majority think she should not be allowed to recover damages for lost enjoyment of life because she's in a coma, so she's not aware of any loss of enjoyment of anything. The dissenting judge would allow her to recover for lost enjoyment of life, even though she's in a coma, because she did lose enjoyment of life, even if she's currently not conscious and aware of it. So this is a really profoundly difficult issue. Should you be able to recover for loss of enjoyment of life if you're not aware of it? On the one hand, you could say the purpose of compensatory damages is to compensate the plaintiff, and if she hasn't experienced pain and suffering or awareness of lost enjoyment of life, if she's unconscious, then she shouldn't be able to recover for those things. The other view is that she should be able to recover for lost enjoyment of life because she did lose it, even if she isn't aware of it. and it seems perverse in a way to give her less damages just because her injury is so severe that she can't even be aware of what she's lost. Another issue in this case is that the jury was asked to give her non-economic damages for two separate things, loss of enjoyment of life and pain and suffering, and the opinion talks about whether those should be separate items of damages or not. In other words, when they give verdict forms to juries to fill out, should the form have two separate blank spaces, one for pain and suffering and one for lost enjoyment of life, or just a single blank space for all kinds of non-economic damages to be awarded together as one amount? Judge Walkler decides that the jury should be asked simply to come up with one amount covering all of it, both pain and suffering and lost enjoyment of life. He fears that otherwise it will wind up being duplicative, and generally higher if juries decide an amount for several different kinds of non-economic damages rather than just one. Courts are divided on these issues. As the note says, courts are split on whether you should be able to recover for loss of enjoyment of life if you're in a coma, and they're also split on the issue of whether to make loss of enjoyment of life a separate category of damages. There aren't really enough decisions on either issue to be certain what is the majority rule. As it says in the reading, Missouri doesn't have any precedent on these questions. But in the note, it mentions a Missouri case called Kenton versus Hyatt Hotels. And it touched on this in a way. It was not about someone who was in a coma, but it was an interesting and sad situation. The plaintiff in that case was a woman named Kay Kenton. She was 28 years old. She had gone to college at KU, and then she worked for a couple of years and saved some money in order to go to law school. And she started as a student here at the UMKC Law School in the fall of 1979. During the summer, after her second year of law school, which was the summer of 1981, she went to a dance at the Hyatt Regency Hotel at Crown Center on the night when the skywalks in that building collapsed and 114 people were killed.
They remember the faces. The gentle sweep of dancing feet as a big band played that Friday in the lobby of the Hyatt Hotel. They remember the warmth of a summer evening, friendly conversations with strangers. They remember laughter, smiles, the sounds of Satin Doll echoing through the room. And they remember the strange sway of crowded skywalks overhead. They remember how time split in two.
And all of a sudden I heard a popping over my head, like steel popping.
Loud bang. I mean, like you can't believe.
People say that 1 minute after 7, other people say it was 3 minutes after 7. But at that time, the skywalk collapsed.
The horror still almost beyond imagination. A concrete skywalk some 40 feet above the floor, crowded with people, tore loose from its misdesigned moorings and fell to a second crowded skywalk below. The combined wreck of steel, concrete, and flesh, then pancaking to the main floor below. In a fog of drywall powder and water spray, a stunned silence, darkness, then chaos, catastrophe.
She survived, but she was injured pretty badly. She had a broken neck and spinal cord damage, and they initially thought she was going to be paralyzed completely, but she had surgery that was miraculously successful and restored some functioning to a lot of her body, but she was still impaired in a lot of ways. There was a great deal of tort litigation about this disaster, as you would imagine, and there was a settlement agreement that was reached in which the two principal defendants, which were Hyatt Hotels and Hallmark, agreed to admit liability in exchange for not having to pay any punitive damages. So the only issue the jury had to decide in Kay Kenton's case was the amount of compensatory damages. A jury awarded her $4 million in compensatory damages. The trial judge cut it to $250,000. Again, judges have a lot of power to cut the amounts that juries award. And so one of the issues in the appeal was whether Missouri law allows someone to recover these kinds of damages for lost enjoyment of life, and the Supreme Court of Missouri said yes. The other big issue was estimating the amount of lost future income. In other words, they had to estimate what Kay Kenton's income would have been without the accident and compare that to what sort of income she would be able to have now that she has these injuries. This led to a dispute about whether her injuries would prevent her from finishing law school and becoming a lawyer. Her doctor and the person who was then the dean of the law school both testified on her behalf. They said that they did not think it would be possible for her to finish law school with the injuries that she had suffered. On the other hand, the defendants brought in a lawyer from St. Louis who had polio, and they had him testify as a witness to show that people with the kinds of physical problems that the plaintiff had are able to go to law school and can practice law. The Supreme Court of Missouri eventually wound up restoring the $4 million jury verdict. Now, let's talk a bit about one small issue which I didn't give you a case for. It's about the plaintiff's responsibility to take care of an injury so that it doesn't become worse than necessary. For example, suppose someone negligently knocks you down and you fall and cut yourself. If you went to the hospital, they could stitch it up for you and it would heal up pretty well. But instead, you don't seek medical treatment, and so the injury doesn't heal as well as it should, and you wind up with a scar. Or let's say somebody breaks one of your bones, and instead of getting it set and immobilized with a cast, you just walk around with it broken, and so it can't heal properly. In these situations, could you recover for the whole injury? Or should your recovery be barred or reduced because you didn't do what you could to minimize the extent of the harm? The rule is that you do need to take reasonable steps to deal with your injury. Traditionally, this was called the doctrine of avoidable consequences, or mitigation of damages. It's a rule that says you have to make reasonable efforts to minimize your injury, and so you can't recover for harm that you could have prevented through some sort of reasonable efforts. So if somebody cuts you, you should go get some stitches instead of bleeding to death. And if you don't, the defendant would still be liable for the original cut that you suffered, but not for the fact that you continued to bleed and died. So this rule was a traditional part of tort law. Most states today say that we don't really need a separate rule for this anymore. We can just handle this as part of comparative fault and causal apportionment. If the plaintiff bled to death rather than making reasonable efforts to minimize the injury, then the jury can assign an appropriate portion of fault to the plaintiff for that. That is what Missouri has done, and that's what most states have done. So the idea behind this rule is still very true. Your damages can be reduced if you don't act reasonably to minimize your injury, but it's unnecessary to have a separate rule for the idea anymore. One thing to consider is how this rule compares to the thin skull or eggshell skull rule, because it's a little bit related to that in some sense, but the rules go in opposite directions. Under the thin skull rule, we don't blame you if you have some kind of pre-existing vulnerability that makes you get hurt worse than the average person would. Like the woman who got hurt at Walmart and also had multiple sclerosis. We don't blame her and reduce her damages on account of her having that physical problem. And if somebody has a super thin skull that gets fractured, that doesn't reduce their recovery of damages. But under this mitigation of damages rule, it is a different story if the person chooses not to get reasonable help with an injury. We can hold that against them and reduce their damages because they made the injury worse than it needed to be. And maybe the difference is that if you have a thin skull, that's not really your choice, so we don't blame you. It's just the way you are. But if you choose to sit there and bleed to death rather than going to the doctor, then that's a choice that you've made. There's one final issue I'll cover here, and it's one that I probably wouldn't even bring up, except that every year someone seems to ask about it, and that issue is taxes. You don't need to know about this for this class. You can learn about it in your tax class. But basically it's like this. You got two types of damages, compensatory and punitive. And we could draw a distinction between two types of compensatory damages. You could have damages for physical injury or physical sickness, or you could have damages for non-physical harm. And the tax laws say that punitive damages are taxable, and damages for non-physical harm are also taxable. But damages for physical injury or physical sickness are not taxable. This doesn't always make a lot of sense. It seems like it might be better to say that you'll be taxed on damages if they are compensation for money you otherwise would have received that would have been taxable. So for example, to the extent the damages are replacing income you would have otherwise received, it seems like you should probably pay tax on that, whether it's for physical injury or sickness or not. But in any event, that's what the tax law does, and there's a lot of litigation about it, because obviously it gives people an incentive to argue that any damages they receive were for physical injury or sickness, particularly if you get the money through a settlement. Imagine if you're suing somebody, and it's really all primarily about non-physical things. But if you can stick some little claim in there about a physical injury, then if you reach a settlement, you can try to claim that all or most of the money was really for the physical injury and try to avoid needing to pay taxes on it. Again, you don't need to know about tax issues for this course, but it's kind of an interesting little side note that people do sometimes wonder about. That is it for today, but we will cover some additional issues about damages in the next assignment.